We are in a position to continue sitting this afternoon until 4:15 to make up the time that was lost this morning, if that is convenient for Council. But if it's not, then if we still need to make up time, we could do so tomorrow morning by starting at 10:15.
I think we would be able to sit on, Lord, if that's...
Well, unless there'd be an assistance, I doubt I'll need the full hour. So the court's probably going to catch that 15 minutes back tomorrow at any rate.
Very well. Okay. Well, in that case, we'll just press on and see if we can do that. Ms. Doherty.
Thank you, my Lord. So I appear for the respondent with Mr. Myhill and Mr. Campbell. My Lords, the short answer to this appeal is that on the facts of this case, the appeal is without merit and should be dismissed, with this court adhering to the interlocutor of the Inner House dated 1st April 2021. I summarise the position for the court as follows. At the centre of this case is a cardiologist whose professional opinion was that a particular class of drugs, non-steroidal anti-inflammatory drugs, would not treat Mr. McCulloch's condition, and so she did not discuss them with him as a treatment option. The factual background was that his presentation was complex. He did not present with straightforward acute pericarditis. He did not complain of pain. The working diagnosis when Dr. Labenjo saw him on the 3rd of April was a respiratory tract infection for which he was being treated with antibiotics. Dr. Labenjo would have recommended treatment with non-steroidals had pain been present, and non-steroidals are known to reduce pain by reducing inflammation. Dr. Labenjo was not aware of any evidence that would support a view that non-steroidals are effective in reducing a pericardial effusion. Given the absence of pain, her view was that the drugs were not a clinically appropriate treatment for Mr. McCulloch. And that was found to be a reasonable view supported by expert opinion applying the Hunter against Hanley test. Now, when I say clinically appropriate, by that I mean a possible treatment that would treat the condition. The respondent submits that whether or not a treatment is clinically appropriate is a matter of professional skill and judgment governed by the Hunter against Hanley and Boland test. Once a treatment is identified as clinically appropriate, it is a reasonable treatment to be discussed with the patient, and that approach is wholly consistent with the decision of the court in Montgomery. Now, in this case, although Dr. Labenjo reasonably concluded that non-steroidals were not clinically appropriate, another body of medical opinion thought the opposite. But at the time of her decision-making on the 3rd of April, she wasn't aware that others held a different view to hers about the use of non-steroidals for patients who were not in pain. At proof, it was never suggested to her or to the expert witnesses, it was not argued in submissions, and it was not held that she should have known on the 3rd of April 2012 that others would have taken a different view to hers, that she should have known there was a second school of thought on the appropriateness of non-steroidals in this case. So in these circumstances, it's my position there was clearly no duty upon her to discuss non-steroidals as a treatment option with the deceased. But in any event, even if the discussion of non-steroidals as a treatment option should have taken place, again, when the facts are considered, there are insufficient findings or evidence relevant to causation that would allow this court to find that Mr. McCulloch firstly would have wished to be treated by non-steroidals, despite Dr. Labenjo's reasonable view that this was clinically inappropriate, that Mr. McCulloch would have been prescribed non-steroidals, and that such a prescription would have changed the outcome. So we therefore advance 3 propositions in response to this appeal, and they're set out really in the respondent's case, and that's at page 122. The respondent's case is found. And the first proposition really is that the lower courts did not err in law as to the appropriate test to determine what is a reasonable treatment option to be discussed with the patient. and that assessment of reasonable treatment options is an exercise of professional skill and judgment and is judged by the test in Hunch against Hanley and Bolam. And the second proposition is that in any event, even if the court accepts the test proposed by the appellants, applying that test to the evidence led and the facts found does not allow a finding that there was a duty to discuss non-steroidals or its extent. And the third proposition is that the evidence led and the facts found do not allow a finding of any causal link between any such breach of duty and Mr McCulloch's death. So, my Lords, I adopt in full the respondent's case, and in that case matters of evidence are dealt with in detail, including pointing out where the appellants have, we say, made only partial summaries of the evidence. And I do rely on all that detail, but clearly don't have time today to refer to all of that. In the respondent's case, again, at section B, there's a summary of the issues to be addressed in this appeal, taken from the agreed statement of facts and issues, and a summary of the respondent's proposed response to each issue. So what I propose, the order I propose to take things in today, Lords, is first to look at the appellant's case on record, and then look at the matters in the order they're set out in the respondent's case in section F, so responding to the appeal, and this will include some reference to section D of the respondent's case, which deals with evidence and findings of the lower courts relevant to non-steroidals. So going first to the case on record, and this is set out in the respondent's case at page 126. So as we see, the appellant's pleadings on information disclosure are limited. The first averment listed there isn't actually a duty, but a factual averment is included as an averment that treatment with anti-inflammatory drugs was another reasonable option. And as is clear from the averments of duty listed there, taken from the pleadings, the duty alleged was to discuss the option of anti-inflammatories with the following stated purposes. It said 3 different ways: to promote the resolution of the pericardial effusion with a view to reducing the size of the effusion and to decrease the size of the effusion. Now, although non-steroidal anti-inflammatory drugs aren't specified in the appellant's averments of duty, there's just reference to anti-inflammatory drugs. All of the evidence in the appellant's case was about the use of non-steroidal anti-inflammatory drugs. And just before we get into the detail of things, I think it might be helpful just to remind the court of what Dr. Lavengeau said about the use of non-steroidals, and part of her evidence is found at page 1702. Now, if you all have that, this is Dr. Lavengeau in response to questions from me, and she explained on page 1701 that she was aware he was receiving antibiotic treatments prescribed by other doctors, and then at page 1702 she confirms that was for the underlying condition, and she thought that was sufficient. And I asked, why did you think that was appropriate and sufficient? And she said there that she thought that the appropriate management in this complex setting, where it appeared the pericardial effusion was being driven by an underlying infection in a man who had had life-threatening infection requiring intubation and ventilation and intensive care for that, she thought it was appropriate to address his problems by treating the underlying case.
Cause, I think.
Cause, I think, is what it should be. And she said, and that is my understanding of the management of pericarditis and pericardial effusion, that you should treat the underlying cause. In addition, there were no ongoing symptoms of pericarditis which would suggest that pain relief would be required. And I don't believe that the prescription of an anti-inflammatory drug would materially influence the pericardial effusion itself. When I asked her why she said that, she said, it's not been my teaching. I don't think there's good evidence to suggest that non-steroidal anti-inflammatory drugs should be given to people simply to assist reabsorption of pericardial fluid. The pericardial fluid gets better by itself if you treat the underlying condition. And we see pericardial effusions in patients without symptoms at echo very commonly. And I'm not aware of any practitioner who feels that an asymptomatic pericardial effusion should be treated with a non-steroidal anti-inflammatory drug. The effusion itself will resolve if you have adequate treatment of the underlying cause. So she didn't clearly feel that non-steroidals were a treatment option for the effusion, and her view was that his underlying condition was being treated and that would mean that the effusion would resolve. So with that background, if I can now deal with the first proposition, which was that lower courts did not err in law as to the appropriate test to determine what is a reasonable treatment option to be discussed with a patient. An assessment of reasonable treatment options is an exercise of professional skill and judgment, and judged by the test in Hunter against Hanley and Bolam. Now, the relevant agreed issues in the Statement of Facts and Issues are, reproduced really in the Respondent's case at the Respondent's case 4.1 and 4.2. And the questions were what legal test should be applied to the assessment as to whether an alternative treatment is reasonable and requires to be discussed as envisaged in Montgomery, and in particular, did the Inner House and Lord Ordinary err in law?
I suppose, thinking about the exchanges this morning, one can talk about the Bolam test in a rather generalized way, but when you think about it, it's or Hunter and Hanley, what it's doing is judging something by the standard of professional opinion, of a responsible body of professional opinion. But what it is that you're judging may vary from one context to another. Mr. Weir hasn't put it like this at all, but his submissions have drawn attention, at any rate, to the danger that at the stage of determining what alternative treatments might be reasonable,
yes,
and which therefore ought to be discussed with the patient, it would be wrong for the doctor to confine herself to what she thought was the best treatment if there were reasonable alternatives.
yes.
And you could, it's an unusual, it's not the typical way in which you apply the Hunter and Hanley test, because normally you're looking at the treatment that was given to a patient and you're asking, was that treatment in accordance with a recognized body of professional opinion? But that's not what we're doing when we're when we're following Montgomery. We're asking whether the alternative treatments that were considered as reasonably were considered reasonable, and were therefore ones which ought to be discussed with the patient. You look at a range of alternatives,
Yes.
and you're applying the test of responsible body of medical opinion in order to determine what that range is,
Exactly.
rather than to identify whether a particular form of treatment was negligent or not.
Exactly. It's the reasonable body of opinion about what treatments are available to clinically treat this condition, and it's the range, and it's that is determined, we say, by the Hunter against Hanley test.
Yes, and obviously, if that stage were misunderstood as being what treatment do I, as the treating doctor, think is the right treatment for this patient, you would narrow down that first stage way beyond what was intended in Montgomery, and hollow it out, as I think Mr.
Yes, and that's
put it.
the respondent's submission is that that doesn't happen. There's not the filtering by the doctor at that stage of what the doctor thinks is best. The doctor has, we say, has to inform the patient of all of the reasonable treatment options. Yes, the doctor may have a preference and would explain that and recommend a particular treatment or not. But that's where the patient choice comes in. The patient's choice can only be an informed choice if they know the range, and it's the Bolam test that applies to the range.
Yes. And if I may say so, I was putting to Mr. Weir the comment that his approach might be excessively forensic, essentially focusing on what a court might do with the benefit of hindsight. But if you're putting yourself in the shoes of the doctor inevitably is going to base her assessment of what the reasonable alternatives are on professional education, experience, and skill.
Yes, and I think the submissions from the interveners have stressed some concerns they would have about the test being different.
Yeah.
But we say that our interpretation of Montgomery is consistent with the words that are in Montgomery on its plain reading and also its intention, because from the plain reading of Montgomery, it's clear from 82 and 83 that the court felt decisions about what were treatments was for the medical profession. Mm-hmm. There's nothing there that suggests that the court gets involved in clinical decisions about treatment. And we can see why risks are different, but the medical profession still has to determine what are risks, and then the court considers what are material risks to be disclosed.
Yes. Yes, so really the danger would lie if it were thought that when we refer to Bolam or Hunter and Hanley at that stage, we're using it in the way we normally use it in the context of medical negligence, to focus on one particular form of treatment and whether or not that was, in other words, the preferred form of treatment and whether or not that was in accordance with a recognised body of professional opinion.
Yeah, but that's not our position. It's not what we think is said in Montgomery. So, I mean, obviously, the court's already looked at Montgomery, but we can look again. So it's at page 2990. And at 81, paragraph 81, so that's at 3021. At 81, there's reference to the social and legal developments which should point away from a model of a relationship between the doctor and the patient based on medical paternalism. And then at 82, we've already looked at this paragraph, but particularly over on the next page, so it's at page 3022, where it said that the patient has an entitlement to decide whether or not to incur a risk. The existence of that entitlement and the fact that its exercise does not depend exclusively on medical considerations are important. They point to a fundamental distinction between, on the one hand, the doctor's role when considering possible investigatory or treatment options, and on the other, her role in discussing with the patient any recommended treatment and possible alternatives and the risks of injury which may be involved. And in the first sentence of 83, the former role is an exercise of professional skill and judgment. What risks of injury are involved in operation, for example, is a matter falling within the expertise of the medical profession. And then it goes on to explain that it doesn't follow from that. The question of whether a risk of injury or the availability of an alternative form of treatment ought to be discussed with the patient is also a matter of purely professional judgment. The doctor's advisory role cannot be regarded as solely an exercise of medical skill. And that, of course, leads on to paragraph 87, which has already been referred to, and that's at page 3023, which sets out, of course, the correct test in relation to the risks of injury involved of treatment. And it says there, between B and C, the doctor is therefore under a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatments. And then the test of materiality is set out there. So it's clear that the duty to advise the patient of material risks doesn't fall within the scope of the whole professional practice test. And so to that extent, Montgomery did mark the end of the area of medical paternalism, where the doctor, judged by Bolam, decided what had to be discussed with the patient about risks in a treatment.
Yes, but you only get to consider the risk. The doctor only considers the risk in terms of discussing it with the patient once she has decided both what is the recommended course of treatment and what are the reasonable alternatives.
Yes.
And that's stage one.
Stage one.
And your interpretation of Montgomery is a Hunter and Hanley question.
It is.
Yeah.
So, our position that what's said about the court deciding what risks are material doesn't impact on the law which applies to the doctor's role when considering possible treatment options. We see, as it explains at 82 and 83 of Montgomery, this role requires professional skill and judgment. So although there is a duty to take reasonable care to disclose information, and that's what's set out in 87, aspects of what is to be disclosed rely on professional skill and judgment, governed by Bolam and Hunter against Hanley. Now, the appellants appear to accept that the doctor's role when considering possible treatment options is an exercise of professional skill and judgment determined by Bolam, and I don't want to take the court to the appellant's case, but that's at 20, subparagraph 1, 28 and 29, and it's found in the bundle at page 94, 96 and 97. And this approach that when the doctor is considering possible treatment options, it's an exercise of professional skill and judgment, is supported by the Court of Appeal decision in Juice, that has already been mentioned this morning, when the nature of the duty in Montgomery was discussed. Now, Juice is found at page number 2828. And as we've already looked at, paragraph 33, and that's found at page 2835, my Lord Hamblin, then Lord Justice Hamblin, explained there the different roles for a doctor identified in Montgomery gave rise to a two-stage test, and this was in relation to risks. So first stage, what risks associated with an operation were or should have been known to the medical profession in question, and that's a matter following with the expertise of medical professionals. And then 2, whether the patient should have been told about such risks by reference to whether they were material, and that is a matter for the court to determine. So the respondents submit that the identification of possible treatment options for a condition similarly falls within medical expertise, just as identification of risks associated with treatment does. And the identification of possible treatment options is therefore dealt with at the first stage of the two-stage test set out there. So whether or not the treatment was or should have been known to the doctor in question is a matter falling within the expertise of medical professions, and it's only once treatment options have been identified using medical expertise at the second stage of advising the patient arises. Now, I just pause here to submit that it's clear from the judgment of the Lord Order in this case that Dr. Lavengeau did not consider that treatment by non-steroidals was a treatment which was given to promote the resolution of pericardial effusions, given with a view to reducing the size of effusions, or given to decrease the size of the effusions. And these were the three riders to the alleged duty to discuss non-steroidals in the appellant's case. These were the stated purposes of the non-steroidals.
Just before you go there, can you just help me with this? I mean, clearly the two-stage test that you've taken to as to induce,
Yes.
paragraph 33, is not focusing quite on the reasonable alternative question that we've got placed before us. So how do you see those two tests as incorporating the question that we are concerned with here? Am I right in thinking that we've got effectively an initial stage before you get to these two questions, an initial stage on your submission being the determination of what is a reasonable treatment, or it might be the preferred treatment, or at least reasonable alternatives, which is a matter depending on an application of Bolan,
Yes.
including knowledge,
Yes.
and then you come to what risks. In other words, you then go into the two-stage test, perhaps.
Yeah, well, I think that works, my Lord, but what we were doing was basically explaining that as for risks, and risks are a matter for the medical profession, and I don't think that's disputed by anybody, the actual risks are a matter for the medical profession. Whether or not they're material and required to be told to the patient is a matter for the court, but risks are a matter for the medical profession, and that's what's set out there at 1. And similarly, we say, according to Montgomery, treatment options are a matter for the medical profession. So it could be a 3-stage test, my Lord, or we could simply put in treatment options instead of risks in stage 1, which is what we have done, and I think what my learned friend was doing when he referred to this test as well. But of course, a decision has to be made about diagnosis and then treatment options. What are the treatment options? What are the risks with those treatment options? That is the process.
So it doesn't have to be sequential in your approach.
I think
the appellant would look at it as a holistic exercise.
Well, and I think the BMA in their submissions, I think they say it's not necessarily it's more holistic is their view of it. But
yes, because what's appropriate treatment may take account of obviously the risks.
Yes, well, of course, it may be that the risks are so high that it's not a clinically appropriate treatment.
Yes, but once you've selected things as being clinical, as being appropriate,
yes,
or relevant alternatives, you then have to consider what risks are
yes,
material, what risks are involved in those alternatives, in those various treatments, the recommended one, the alternative one, and also what you have to tell the patient. The latter question not being a matter purely for the medical practitioner.
Yes, Lord.
Thank you.
So what the respondents say is that the appellants here must fail at the first stage of that 2-stage test. This was non-steroidals were not a clinically appropriate treatment option in this case, and the appellants didn't prove that Dr. Lavengeau should have known otherwise. They were not treatment option to resolve or promote the resolution of the effusion. Yes, she didn't regard them to be a possible treatment, and by that I mean a treatment which would actually treat the condition, and her view of that was upheld by Dr. Bloomfield, and the court accepted that as reasonable. And so we say that we're in the position which happened in Deuce, where, as set out at paragraph 42, the claim failed at the first hurdle. And in Deuce, the claim failed because the judge wasn't satisfied that there was proof that gynecologists were or should have been aware of the relevant risks, which is a matter for expert evidence. And here we say the claim fails because the appellants haven't proved that giving non-steroidals was an appropriate treatment option. So the correct approach to stage 2 of actually advising the patient is, of course, an important matter, but it will not determine the outcome of this appeal on the facts of this case. It's academic. Now,
and you say that's the case even on the submissions put against you?
Yes. Now, given that Montgomery at paragraph 87 has been looked at many times, but I do just want to look at it one more time. It's at page 3023. And the way it's worded is that the doctor is under a duty to take reasonable care to ensure, first, that the patient is aware of any material risks involved in any recommended treatment, and secondly, of any reasonable alternative or variant treatments. Now, the respondent accepts that, but a question for the court, of course, is what amounts to a reasonable alternative treatment and who decides this. And as I've already said, the respondent's position, and it's set out more fully in the respondent's case at paragraph 27, the respondent's position is that reasonable in paragraph 87 in Montgomery simply means clinically reasonable, clinically appropriate, a possible treatment which will treat the condition. And as I've said already, at 82 and 83, the court makes clear that in considering possible investigatory or treatment options, that role is an exercise of professional skill and judgment. There's nothing said there in Montgomery to suggest that the court is involved in this clinical assessment. Rather, it says this assessment of treatment options requires professional skill and judgment. And as I've set out in the respondent's case at 27, the respondent's position is that once possible treatments, clinically appropriate treatment to treat the condition, have been identified by the doctor, these should be discussed with the patient. There's no filtering by the doctor of what clinically appropriate treatments are to be discussed with the patient. All such treatments should be discussed. And this is all set out more fully in the respondent's case at 32 and 33.
Of course, before one can consider treatment, one has to first have decided what the condition is that has to be treated.
Yes.
And I think have shown us the evidence that the doctor in this case didn't diagnose pericarditis as a condition requiring treatment.
No, she regarded the pericarditis as being related to an underlying condition, and the practice is to treat the underlying condition.
Yeah.
And when she saw him, she described him as not having pain, so he had asymptomatic pericarditis. And I think from the reference to her evidence,
I see, yes.
It wasn't something she had to do something about. He was already being treated for the underlying condition, and usually that would then resolve the issue of pericarditis and effusion.
Oh, I see. Sorry, I got that. I got that wrong.
I will come on to that.
So she had diagnosed pericarditis and pericardial effusion, but regarded those as essentially being secondary to the respiratory tract infection.
Yes.
And the things that would resolve themselves if that infection were.
Yes. What he did not have on the 3rd of April was acute idiopathic pericarditis, which can be a standalone condition. He was regarded, rather than being a patient with that condition, he was regarded as a patient who had an underlying condition. When he was first admitted to hospital, he was very seriously ill and had sepsis and required extensive treatment. None of that is what would be expected with a standard presentation of acute pericarditis, which sometimes just gets better by itself. So,
the underlying condition, as she understood it, was what exactly was that? Is that the tract infection? Or?
Yeah, the working diagnosis when she saw him, according to the medical records, and this is agreed in the Statement of Facts and Issues, the working definition at that time was respiratory tract infection, and he was in receipt of antibiotics for that.
So it was lower respiratory tract infection, I think, wasn't it? It was further down
Yes, yes, sorry, yes.
the respiratory tract. Yes.
Yes, and I suppose the other feature in this case is that Dr. Lavengeau went to see him on the 3rd of April because she had been asked to review an echocardiogram. She was not his treating doctor. She went to see him to try to get a better picture, really. But she was not his treating doctor at all. He'd been seen by many doctors and, in fact, other cardiologists, and no one had prescribed non-steroidals, although he had pericarditis and a pericardial effusion. Yeah. And as agreed in the Statement of Facts and Issues, by the time she saw him on the 3rd of April, his condition was described as clinically well, certainly compared to what he'd been like when she'd seen him before, because she had seen him in his first admission when he was very ill.
Yes, the Lord Ordinary discussed that, didn't he? Because Mrs. McCulloch gave contrary evidence, and the Lord Ordinary's judgment was that he couldn't accept that.
Yes.
In the light of the other evidence available.
So, in the respondent's case at section D, and that's found at page 127 to 130, I deal with the evidence and findings of the lower courts relevant to this issue about whether non-steroidals were a reasonable alternative treatment which required to be discussed. Now, I won't go into the detail of the evidence set out there, but just refer to the findings made in relation to reasonable treatment options. And as set out there, at paragraph 12, the Lord Ordinary found that in Dr. Lavengeau's professional opinion, non-steroidals were not a reasonable treatment option in the circumstances of this case. She did not, in her professional judgment, regard it as appropriate to prescribe non-steroidals when Mr. McCulloch was not in pain, and that's found in the Lord Ordinary's decision at paragraph 112. And then paragraph 13 of the respondent's case, the Lord Ordinary found that she was supported in her position by a responsible body of medical opinion, which held the view that non-steroidals were given to relieve pain, not reduce an effusion. That's the Lord Ordinary at 91. Then later on, in the Lord Ordinary concluded at paragraph 112 that there was no reasonable alternative to discuss with Mr McCulloch. He agreed with the interpretation of Montgomery set out by Lord Boyd in the case of AH that we discussed that this morning. So this, if your Lordships, it's the Lord Ordinary's decision. It's at paragraph 110 and 11, and that's found page 260 and 261, when he sets out at 110 what was said by Lord Boyd in AH, and then at 111 he sets out that he agrees with what Lord Boyd said about Montgomery, and then at 1112 he explained that Dr Lavenjo did not prescribe non-steroidals because she didn't, in her professional judgment, regard it as appropriate to do so when he was not in pain. There was no clear diagnosis of pericarditis, and by that it's acute pericarditis on its own. She didn't consider another drug. There's no risk in a recommended course and no reasonable alternative to discuss with him. And then he goes on to say, properly analysed, the pursuer's complaint is that Dr Lavender was negligent in her professional assessment, not that she identified a reasonable alternative of prescribing anti-inflammatories, but then failed to discuss it. And obviously, in his opinion, he was not satisfied that non-steroidals were something which were to be prescribed. And then the Inner House agreed that the duty to advise of non-steroidals did not arise. Now, that's what they said about that. I've quoted in the respondent's case at 34. They felt it didn't arise where the doctor had rejected treatment on the basis it was not a treatment indicated in the circumstances of the case. That's quoted there. And then they went on to agree with what Lord Boyd said and what the Lord Ordinary said. And that's at paragraph 40 of the Inner House decision. They do that. So, now as set out in the respondent's case at 31, which is at page 135, the crux of the dispute between the appellants and the respondent appears to be that the appellants disagree with the respondent's position that the first stage of the two-stage test involves the determination of reasonable alternative treatments, and that is solely a matter of professional skill and judgment. They say that the doctor determines what are possible alternative treatment options, and then the court determines what alternative is reasonable. So my position is that that approach is wrong on a proper reading of Montgomery and its rationale. And for a treatment to be regarded as an alternative treatment option by a doctor, it requires to be something which will treat the condition. So it requires to be clinically appropriate. Otherwise, why would a doctor describe it as an alternative treatment at all? And when I say it's something which will treat the condition, it's something which will benefit the patient's condition either by treating the patient's symptoms or treating the condition. And that is something that's fact-dependent and has to be judged by a medical expert.
So when you speak of clinically appropriate, you're not speaking of the doctor's preference.
No.
You're applying an objective test. Will this treatment benefit the patient in a relevant way?
Yes, and that is determined on the Bull and Hunter against Hanley test. It's not the doctor's own preference. And once the first stage has been completed and clinically appropriate treatments have been identified, the second stage then is to discuss with the patient any of these treatments, or to discuss with the patients all of these treatments and the risks involved. But it is only clinically appropriate treatments which require to be discussed. And what the patient should be told about those treatments and their risks is determined by the wider considerations set out in Montgomery at 87. So, in the response case at 35, it stated there that the appellant's approach is illogical and inconsistent. Now, the appellant's position appears to be the court should decide what are reasonable treatment options based on a range of factors, and they specify 3 factors in their written case at paragraph 4. And in their proposed test set out at 4, they state that the court determines what is a reasonable alternative treatment unshackled from the Bowen test. Yes, they go on to say at subparagraph C3 that the court will take into account. Sorry, just find that myself. Page 89. Sorry, page 88 of the...
That's paragraph 4 of the appellant's case.
Sorry, yes. Paragraph 4 of the appellant's case.
So you're looking at 4C, I think.
4C. They talk about 3 factors: alternative treatments a reasonable person, patient position would be likely to attach significance to, alternative treatments that a particular patient would be likely to attach significance to, and the third one, alternative treatments that the doctor appreciates or should appreciate would be considered reasonable within the medical profession, even though the doctor reasonably elects to recommend a different course of action. So that therefore depends on whether the doctor knows or should know of a reasonable alternative treatment relying on a professional practice test. So they do seem to recognise the involvement of the professional practice test to an extent. But despite this, elsewhere they argue that the professional practice test has no place in determining what are reasonable alternative treatments. Rather, the court should determine this. At 46, which is 101, they seem to assert that a doctor's assessment of the clinical suitability of a treatment is not an exercise of professional judgment, but rather a value judgment. But in my submission, that can't be correct. Whether or not a treatment is clinically suitable must be an exercise of professional judgment. The actual determination of what treatments can treat a condition is a clinical decision, dependent on professional expertise and judgment. But of course, which of a number of clinically appropriate treatment options a doctor particularly recommends is a different issue. So, in conclusion, really, what the appellant suggests that the court should decide on what are reasonable treatment options, I say, is inconsistent with what was said in Montgomery, which clearly stated at 82 and 83 that the doctor's role in considering possible treatment options is an exercise of professional skill and judgment. Now, in their case, and this morning there was reference to other authorities in support of the argument as to the appropriate legal test. In my submission, the reference to these authorities doesn't help the appellants. The response to the authorities is set out fully in the respondent's case. But I would say that in relation to Britain, which was the Sheriff Court decision, which my learned friend referred to extensively, in Britain, both of the two treatments, injections and steroids, were clinically appropriate treatments. In Britain, the court found that the ophthalmologist was aware that steroid injection was an alternative treatment to the treatment actually given, which was oral steroids. But he regarded it as not as effective, and so he effectively substituted his own view for the patient's as to whether that lower efficacy of a steroid injection would have been acceptable. Now, it would be consistent with our approach in this appeal that the ophthalmologist should have discussed both treatments with the pursuer. It wasn't for him to substitute his own views of the risks and benefits for the patient. Of course, the facts in Britain were very different from the present case, where Dr. Lavengeau didn't consider that non-steroidals would have given any clinical benefit given the absence of pain, so it wasn't a clinically appropriate treatment at all. And in Webster, which was mentioned this morning again, the doctor ought to have been aware of the risks involved. Now, because of pressures of time, I won't deal more fully with the other cases that my friend referred to, apart from the decision of Lord Boyd, which was referred to, and this is a decision that both the Lord Ordinary and the Inner House expressly agreed with in this case. And the relevant passage in this case is found in the bundle at page 2570.
I don't know whether you do deal with this anywhere or intend to do so. What about this Alberta decision of Saney? Do you have any submissions on that?
I do. I'm trying to find where my notes we deal with that, but I do deal with that word.
Is that something you're coming to?
Yes, but for fear of not making it to it, I can try and find it now. Thank you. Yes, so Senny was a case that the appellants have relied upon, and it's found in the bundle at page 3337. And the facts in short were that the plaintiff broke her wrist, it was treated with a cast. When the defendant, an orthopaedic specialist, reviewed her, he recast the wrist despite the fact that the wrist was not healing in alignment. He did not advise of potential alternative treatment to using a cast. And at 58, paragraph 58, so that's found at page 3354. Yes. As said there, the alternative medical procedure in this case was not a fringe alternative. You go over the page. It was not an alternative offered outside the speciality of orthopaedics or by some other form of healthcare. This case turns on its own facts. And the evidence accepted by the trial judge was that the profession had been familiar with this alternative procedure for many years. Not only was it a known procedure, it was a procedure preferred by some of the orthopaedic specialists in this city. And at 64, so that's at page 3356, at the end of that paragraph, the court said, the mere fact that a doctor prefers one treatment over another does not relieve him of the obligation to advise of other acceptable and known procedures. That is what the duty to inform is all about. And then at paragraph 70. Again, it's the trial judge obviously found that the alternative treatment was not unreasonable. Both experts said it was a common method. So that's entirely consistent with the respondent's position that if there are potential alternative treatments, even if the doctor personally doesn't like using them, the patient should be advised of them.
It rather looks as though, well, so far anyway, I'm not sure there's anything in this you would disagree with.
Well, I don't think it helps the appellants, Lord, no.
I know you may be wary of being tempted into an indiscreet concession, but it still seems to be, the judge seems to be using a test of effectively medical expertise in deciding what the range is of alternative treatments which ought to be made known to the patient.
Yes, I think that the key thing, Lord, is that it was a known procedure, and that is what...
Yes, that's explicit at paragraph 64.
Yes, and it's stressed at... sorry, I'm pointed here.
The obligation is to advise of other acceptable and known procedures.
Sorry, Lord.
The obligation, it said at 64, is to advise of other acceptable and known procedures.
Yes. Yeah, and I think the doctor testified at paragraph 70, it says that he was aware of the alternate procedure, but he was of the opinion a satisfactory result could be attained without it. So he used his own view rather than advising the patient of the options. And again, that's what we say is in contrast to our position, the facts of this case. So I think I had proposed to take the court to Lord Boyd's decision. And at page 2571, yes, and I think the court's already been taken to paragraph 42 and 43, where Lord Boyd explained the two arguments put forward, and he preferred the submissions for the doctors. But the range of alternatives are those that the doctor considers reasonable, exercising his or her skill and expertise as a reasonable, competent doctor, and which are available. So as set out in the respondent's case at paragraph 39, and that's at page 139, the appellant's criticisms of Lord Boyd's approach are ill-founded. Again, as I've said, the medical profession must determine what treatments are available to treat a condition, and the patient should be told about these options so he can choose. And then where the appellants criticise Lord Boyd's concern that a doctor shouldn't be required to advise an alternative procedure that, if performed, would amount to a breach of duty, I would say that's misconceived. The appellants appear to interpret what Lord Boyd has said there as being that a doctor can only provide treatment that he recommends, and that is not what Lord Boyd has said. There may, of course, be a number of treatments which are clinically appropriate and which the doctor would be willing to provide, although, of course, the doctor may particularly recommend one or more of those to the patient. And, in fact, this approach that the patient should be told of all the clinically appropriate options is consistent with the approach of a Canadian case, which the appellants rely upon in their case at 57, And the case is Van Moll against Ashmore, and it's found in the bundle at 3368.
Sorry, I missed that page.
3368.
Thank you.
And there the court held there was a failure to inform the patient who was to undergo heart surgery of the 3 alternative techniques available and their risks and benefits, and that's found at page 3370. The middle paragraph there. And the court held that the patient was entitled to know about these 3 alternative techniques and the risks and advantages of both. And then at page 3413, paragraph 127, it said that Dr. Ashmore was required to tell Melanie about the 3 alternative methods for this 3rd repair operation, including the methods that were available and in widespread use. So all of that is consistent with the respondent's position. Now, one matter not addressed in the respondent's case, and I don't think it was really discussed this morning, is a limit on the potentially clinically appropriate treatments to be discussed might be their availability. In Montgomery, at paragraph 87, it said that the patient is entitled to decide which, if any, of the available forms of treatment to undergo. So the patient should be told of all reasonable, by that I mean clinically appropriate alternative treatments, but the treatments required to be available. And whether a potential treatment is available is a fact-sensitive issue. In the facts of this case, availability was not an issue which arose. There was no dispute that non-steroidals would have been potentially available. They're readily available, but they were not an appropriate treatment option. So although the issue didn't arise in this case, our interpretation of what is said in Montgomery is that if there is a clinically appropriate treatment which could be accessed by the patient and which the patient is or ought to be aware of on the Bolam or Hunter against Hanley test, then the patient should be told about it. Oh, sorry.
Which the doctor?
Yes, I've just been corrected on that, sorry, apologies. Should be told about it. So, a possible example would be a treatment which might only be available privately, but that might be potentially accessible to the patient, so the patient should be told about it. Perhaps a situation like a knee replacement, where a patient might not reach the threshold to be offered a knee replacement on the NHS, but he may be able to access that privately. But we say the Bolam and Hunter against Hanley test still requires to determine what are the available clinically appropriate treatments. But as I said, that was not an issue which arose in this case. It was just something we were considering when we were considering how Montgomery should be interpreted. Now, in the respondent's case, there's a section at page 140 onwards of the case, headed up Awareness of the Views of a Different Body of Responsible Opinion. And as is set out there at paragraph 44 of the respondent's case, what is advanced now by the appellants as to the appropriate test, as to assessing what's a reasonable alternative treatment, wasn't something that was argued before the lower courts. It was raised for the first time in this appeal. This appeal is the first time we've seen this test as set out in the appellant's case at paragraph 4. The position advanced by the appellants before the lower courts was that what was a reasonable treatment to be discussed with the patient was a question of fact to be addressed by the court, not determined by the standard what a doctor of ordinary skill acting with ordinary care would have assessed as a reasonable treatment, and the lower courts rejected that submission. Now, what I go on to discuss in this next part of the case is really the hypothetical case, because of the way the appellants worded their test in paragraph 4, it wasn't clear to us whether they were going to argue that Dr. Lavengel should have known about the treatment option of non-steroidals because a reasonable body did regard them as an option, as the Lord Ordinary found. He didn't reject Dr. Flappin's view that giving non-steroidals was a reasonable course of action, nor did he reject Dr. Bloomfield's view that it was reasonable not to give them and they weren't a reasonable treatment option. So because of the way the appellants worded, as I said, their proposed test at 4, we were concerned that they were going to try to argue that she should have been aware that there was a body of people, in this case represented by Dr. Flappin, who considered that they were an alternative treatment. This, of course, was not raised in evidence or in submissions, and therefore the lower courts didn't opine on it. So that's the explanation really for what is set out, and my learned friend took you to this morning in the respondent's case at page 124, where it's set out the issue 6.3, our response to the issue. We suggested that where a doctor is aware there is a responsible body of medical opinion which regards the treatment as reasonable, although the doctor herself, with the support of her responsible body of medical opinion, does not regard the treatment as reasonable, the doctor requires to discuss that alternative with the patient. But whether the doctor should be aware of this should be so aware of this second responsible body of medical opinion, and what she should be aware of that should be determined on the Hunter against Hanley and Bolam test.
Which page are you reading from?
I'm reading from page 124 and 125 of the respondent's case, and it was 6.3, and my learned friend referred to this morning and described it as Bolam plus. Now, having heard the submissions made this morning, it appears to be the appellant's position that, in fact, what they mean is that Dr. Lavengel should have known that non-steroidals were an alternative treatment to be discussed because she knew of them and she often gave them in a standard case. I don't think they seem to be arguing that she should have known that there was a body of opinion like Dr. Flappin's. So given that that doesn't really seem to be an issue which this respondent is having to face now in this appeal, it may be that what is really a hypothetical case then, as set out at 6.3, does not arise on the facts here now, and maybe it's not something which the court requires to consider further in the facts of this case. So
are you reverting from Montgomery Plus to Montgomery?
Well, I don't think Montgomery Plus is what the appellants are now, if I understand their submissions, is what they're arguing. So.
Well, we obviously have to look at the law more generally than the facts of the individual case. Yes. You make powerful points that this wasn't a case before the Lord Ordinary. There is no finding that Dr. Lavengel knew of this alternative view, nor is there any case or finding that she ought to have known.
Yes.
And you say on the facts of this case, that's the end of that matter.
Yes.
But we obviously have to consider the application of the law to other cases. So am I to understand it that you're really inviting us to put a line through 6.3 for the present purpose in this appeal?
Well, I think
I was struck by this when I read it, because it seemed to me that 6.3 was more consistent with your fallback position on issue 7, which so your primary position seemed to be, well, look, it's a matter of assessing what the doctor, supported by a responsible body of opinion, considers to be the appropriate range of treatments. But if I'm wrong about that, then then you get to issue 7.
yes. Well, and issue 7 is the one that the respondent suggested because of the way we were understanding the appellant's case. We thought, well, yes, if she's only to tell the patient because she's aware of an
I'm struggling to tie 6.3 into your oral submission today, because my understanding was that on the first stage of the assessment of the appropriate treatment, that was simply a Hunter against Hanley, yes, test as to what the doctor identified as being the appropriate treatments, and then asking, is that supported by a respectable body of opinion, and the court on Bolitho basis considered as reasonable.
Yes. In
which case we don't get into 6.3 at all.
Yeah. I think you're right, my Lord. I'm content that we don't need to argue this point now, Lord, now that I understand what the appellant's position actually is. So, Lord, obviously there are interveners in this case. There appears to be some difference between the response approach and that, at least, of the BMA. Obviously, we put forward our interpretation of the legal test. But even if this court accepts the BMA's approach, this will not change the outcome of the appeal. On the facts of this case, the appeal should still be dismissed.
Yeah, so as Lord Hodges pointed out, the important, I mean, this is one of the most important medical negligence cases in a long time, and it's not because of its impact on the McCulloch family. I mean, that's obviously a matter of importance to them, but that's not why this case is here.
Yes. Yes, Lord. But what the BMA agrees that the assessment of what treatment options are clinically appropriate is a matter of professional skill and judgment. But then the BMA's position, as I understand it, is that prior to giving advice, the doctor must determine whether the clinically appropriate treatments should be discussed with the patients as reasonable alternative treatments. So that's effectively a filter, it seems, on what should be told.
Which paragraph are you looking at in the BMA?
The BMA is page 3472, paragraph 23 onwards.
Thank you.
3472, did you say?
Yes, Lord.
Thank you.
Yes, so 22, they say, which of the potential options for treatment should be communicated? And they say this part of the process is of a different character. Now, and they say it's paragraph 32. Perhaps not 32. 37. They say it would be wholly unworkable to place upon doctors an obligation to raise and discuss every realistic and available treatment with every patient. That wouldn't be in the patient's interest. Now, clearly this is different from the approach which we've suggested, but in relation to potential practical difficulties, there may, of course, be broader considerations which do not apply in the facts of this case, where it was relatively simple. The issue related to whether there was one alternative treatment which should have been discussed. But as I say, the respondent's position is that using the Bolam test, the doctor should assess the range of clinically appropriate treatments, and then they should be discussed with the patient.
Yes, I mean, do you disagree with what is said in paragraph 38.1 to 38.3?
Well, 38.3 is effectively a filter, my lord. So to the extent that that's inconsistent with, if that's what's meant by that, which I think it is, I think the BMA approach is to filter from the range by using what a reasonable person in a patient's position would be likely to attach significance to. And on our analysis of what is said in Montgomery at 87, that is inconsistent with what's said in Montgomery.
So your submission is that all reasonable alternative treatments, that is clinically suitable treatments, must be discussed with the patient. And the BMA, as you understand it, is limiting that to a degree.
Yes. Now, the GMC are also intervening. You'll hear oral submissions from Mr. Dunlop tomorrow, but at paragraph 15 of their submissions, which I think is page 175.
Pardon, 17?
I think it's 175, Lord, I'll just check.
Thank you.
It is.
Thank you. They expressly state they don't offer a view as to the legal test, but do say that a consideration of reasonableness in this context cannot be shorn of professional judgment. So as far as this goes, it is consistent with the respondent's position. I now propose to move on from this chapter of my submission and turn to my second proposition, which, in any event, even if the court accepts the test proposed by the appellants, applying that test to the evidence-led and facts found does not allow a finding that there was a duty to discuss non-steroidals or its extent. And the relevant agreed issues to that are found in the respondent's case at page 123 to 4. So, issue 3, if applying the correct test where non-steroidal is a correct, reasonable alternative treatment for pericarditis / to reduce the size of the effusion that Dr. Lavender was required to discuss with Mr. McCulloch. And then 7, in the event there was a duty by her to discuss non-steroidals, what was the extent of that duty upon her? Now, these issues are discussed in the respondent's case at page 143 to 149 under the heading Insufficient Evidence and Findings in Fact for the Alleged Duty or its Extent. So first, was there a duty to discuss non-steroidals? And as set out there in the respondent's case at paragraph 50 to 58, the evidence-led and findings do not support that such a duty arose. Now, the appellants in this appeal do not challenge the findings on the evidence, apart from asserting that the Inner House was wrong to conclude that the literature doesn't seem to support the assertion that non-steroidals have a benefit beyond pain relief. And I'll come back to that. But as set out in the response case at 51, Dr. Lavendrow's evidence, which was held to be reliable and credible, is summarised there. And the court may also find it useful to refer to section D of the response case, and that's at page 127 to 130, for the summary there of evidence and findings and the specific reference to extracts of evidence, which, for reasons of time, I won't be able to go to today. The lower courts held that there was no duty on Dr. Lavendrow to disclose and discuss treatment options, in particular non-steroidals, which she did not regard as a reasonable alternative treatment. And as noted in the response case at paragraph 51, that's at page 143, she did not regard non-steroidals as clinically appropriate in the absence of pain. They would not reduce the effusion. Now, as noted at the end of paragraph 51 of the response case, and that's at page...
I note you say there that wasn't challenged.
That wasn't challenged.
Because it's quite an important part of the case now being made against you.
Yes.
Is that NSAIDs would not just deal with pain, but would reduce the effusion by reducing the inflammation.
That wasn't challenged.
That wasn't an issue before the Lord Ordinary. Okay.
It was their expert's case, wasn't it?
It was their expert's case. But her evidence that she didn't regard non-steroidals as effective in treating effusions was not challenged.
No, but what was the expert case put to her? The contrary view?
No, I don't think it was, Lord. So, at the end of paragraph 51, that's at page 144, as it said there, in the appellant's case, it repeatedly said that he received no substantive treatment for his underlying condition after his readmission to hospital on 1st April. Now, this is inaccurate. As I've already said, he was still being given antibiotics for his respiratory tract infection, which was understood to be his underlying condition. When acute pericarditis is not viral or idiopathic, it is managed by treating the underlying condition. Now, that has obviously been Dr. Lavendrow's evidence, and I've already directed you to that. But I also now refer you to two extracts of literature which the Inner House referred to in its opinion at paragraph 45.1, but the particular passages that I will refer you to, the Inner House did not quote in their opinion. And the first is found at page 1089. And it's diagnosis and management of pericardial disease by Kandahar, and it's page 109. And the paragraph I want to refer you to, it's 1069. Have I got these pages muddled up? No, it's not. Sorry, I'm wrong with my page reference. The page reference should be 1094. So this is an extract from Kandahar, and the Inner House quoted the first column. The Inner House quoted the final paragraph under the heading non-steroidal anti-inflammatory drugs. That ibuprofen or aspirin has been most commonly used and provides prompt relief of pain in most patients, but does not alter the natural history of the disease. Now, the Inner House quoted that in their opinion. at 45.1, but they didn't refer to the earlier paragraph here, which is under the heading treatment, which reads, when the identified etiology of acute pericarditis is not viral or idiopathic, management should be directed toward treating the underlying cause. And another piece of literature that the Inner House referred to was the current diagnosis and treatment by Crawford, and that extract is found page 1069. And again, in the Inner House, they quoted, it was under the heading treatment, they quoted the second sentence, in the usual case of idiopathic acute pericarditis, treatment with any of the non-steroidals usually suppresses the clinical manifestations within 24 to 48 hours. But the sentence I'm interested in is the sentence above, which is the management of pericarditis associated with an identifiable etiology is directed primarily to the underlying cause.
Sorry, can you give me that page again?
Sorry, my Lord, it's page 1069.
Thank you.
What's the sentence you want us to look at?
It's the first sentence under the heading treatment, which is basically saying the management's directed primarily to the underlying cause.
Indomethacin is mentioned in the right-hand column. Is that an anti-inflammatory?
Sorry, my Lord, I didn't catch that.
Indomethacin is mentioned in the right-hand column there on the page you've referred us to under treatment. Talks about aspirin, indomethacin.
I don't know, my Lord.
Page 1069.
Yes.
It's just reading on from the passage you took us to.
We didn't hear any evidence about that, my Lord, at all.
I see.
So, sorry. Sorry, turning back to the respondent's case at paragraph 53.
Just before we go there,
Yes.
when the paper speaks of clinical manifestations, is that a synonym for symptoms? Do you know?
Yes, and the classic symptom is chest pain with pericarditis. And that, I think, if we look at just the page before it, 1068, under the heading clinical findings, it says symptoms and signs.
Which page are we at?
1068.
Ah, yes.
Under clinical findings, symptoms and signs. The
Chest
primary,
pain.
sorry,
Yeah.
the primary symptom of acute pericarditis is chest pain. So, going back to the respondent's case at paragraph 53, reasons are listed why the appellants cannot succeed in their assertion that Dr. Lavender was under a duty to discuss non-steroidals, despite the fact that she, and supported by a responsible body, did not regard them as clinically appropriate. So as set out there, 53.1, she didn't consider them to be clinically appropriate in the absence of pain, so they were not a treatment option in the circumstances of the deceased. And this view was not challenged. It wasn't put to her that she ought to have discussed non-steroidals with the deceased as a reasonable treatment option. She was not aware of evidence that non-steroidals would reduce the size of an effusion, and again, this was not challenged by the appellants. And there's reference back to where more of her evidence is quoted at paragraph 12 of this case. And the next paragraph deals with the fact that she wasn't aware that others would give. And in fact, her evidence that I started with this morning is when she said that she wasn't aware of a practitioner who would give non-steroidals to reduce an effusion. Then at 53.5, the medical literature on which the appellants rely in support of the known use of non-steroidals relates to their use in the standard presentation of acute pericarditis, which includes pain. And this is in complete contrast to this complex presentation, the ongoing antibiotic treatment for the underlying condition, and the fact that he did not have pain on the 3rd of April. And we see at 53.6, the medical literature does not support that non-steroidals promote reduction in the size of the pericardial effusion, and reference is made there to the Inner House decision, paragraph 45(1) and 6. And I'll come on to that later when I deal with causation. And finally, 53.7, the appellant's case required Dr. Labrio to discuss non-steroidals as a treatment option which would promote the resolution of the pericardial effusion, and there's no factual finding that non-steroidals were capable of doing so.
A point which we'll obviously have to consider is arises from your 53.1 and 53.4. 53.1 is saying that because the doctor didn't consider this particular treatment to be clinically appropriate, it follows that they weren't a treatment option.
Yes.
And if so, then they wouldn't be an option that needed to be discussed.
Yes.
53.4
I think
raises a question of a broader test.
53.4 falls away, my Lord, given the discussion we had earlier about not insisting on what has been described.
You're covering your 6.3 point there.
Yeah.
That's what that addresses, and given that we're not insisting on the 6.3 point, but although I have already raised as a matter of fact, Dr. Labrio's evidence was she didn't know anybody that would give non-steroidals to treat an effusion when there wasn't pain. But yes, I think 53.4 flies off really.
I'm just thinking about it in the context of the Alberta case, where the issue was a broken wrist.
Yes.
And whether you just let nature take its course, or whether you whether you reduce the fracture so as to reset the bones. And as I understand the case, what the point in it was that in one part of Alberta, the doctors weren't too concerned about deformities, and so you just let nature take its course. But in another part of in the city, people were more concerned about the cosmetic appearance, and so reducing the fracture was the preferred course of action. But the case seems to proceed on the basis that, rapidly skim reading it, it seems to proceed on the basis that the defendant doctor was aware of, or would have regarded both as being alternative treatment options.
Yes.
Albeit his preference as one of the more robust, perhaps old-fashioned doctors was to let nature take its course.
Yes. And that's in that case there were more. He should have discussed the options, even though he prefers one option. He should have given the patient the opportunity to choose.
Yeah, and if that's the correct reading of it, then it's consistent with your 53.1.
Yes.
And it's not a case where the position being advanced was simply that the doctor. You're not suggesting that the doctor could simply restrict the discussion to his preferred option amongst the range of options which he would have regarded as clinically available.
No, our position is that the doctor doesn't limit the range that are to be discussed. Once there's a range that has on bolum, once there's a clinically appropriate range, they should be discussed. And that didn't happen in the Alberta case.
Yeah.
So carrying on with the respondent's case, at 54, as emphasised there, the presentation in this case was unusual. So although non-steroidals were referred to as a standard treatment for the standard presentation of acute pericarditis, this was not that type of case. And the guidance was of limited relevance, therefore, given Mr. McCulloch's complicated presentation and absence of pain. Now, the next part of the respondent's case addresses what the appellants have as a summary of the backdrop to non-steroidals being a reasonable treatment option. And what we say is that what has been listed there by the appellants is incomplete and selective. I don't have the time today to go through all of what has been set out there in 55, but I would emphasise two things from what is set out there. Again, that Mr. McCulloch's presentation was unusual and complex. It wasn't a standard case of acute pericarditis with chest pain. The impression was that there was an underlying disease, that he didn't just have acute pericarditis on its own. And secondly, the issue of the effectiveness of non-steroidals in reducing the size of an effusion was explored in evidence with the experts, particularly. And the appellant's expert, Dr. Flappen, was a lone voice in support of the efficacy of non-steroidals in reducing the size of an effusion. And Dr. Flappen's reliance on literature to support his view was seriously undermined in cross-examination, and the Lord Ordinary did not attach weight to that part of his evidence. And the Inner House also read that part of Dr. Flappen's cross-examination itself and was similarly unimpressed, if I could put it that way. And I would refer you, please, to the respondent's case at 55.5 for the detailed references to what the Lord Ordinary said about this and what the Inner House said about it, and the references to the evidence that both the Lord Ordinary and the Inner House considered. And again, just to meet the backdrop which has been set out here by the appellants, I would also ask you to refer back to what is set out in the respondent's case at paragraphs 12 and 13 about the backdrop here.
Yes, I mean, in paragraph 82, the Lord Ordinary was very clear after cross-examination that he did not attach any weight to that part of Dr. Flappen's evidence,
yes,
because of the statistical inadequacy of the material.
Dr. Flappen was attempting to rely on clinical trials, and the court wasn't satisfied that he was entitled to rely on them in the way he attempted to. For the propositions that he sought to draw from them were not capable of being drawn, and the statistics, again, he misrepresented really the statistical position, so he didn't put any weight on that. Mm-hmm. And so again, the written case sets out there at 56 that quite simply there's insufficient evidence to allow a finding that Dr. Lavengel knew or ought to have known that they were something to reduce the effusion despite her own contrary view. Paragraph 58, what is said by the respondents there hopefully is self-explanatory. Again, the assertions made in the appellant's case are inaccurate, and we've tried to highlight why that is. The next part of the respondent's case deals with the content of the alleged duty. So if there was to be a discussion about non-steroidals, what was Dr. Lavengel supposed to say, given her own personal and reasonable view that non-steroidals were not appropriate? Now, there's no evidence about this, no findings by the lower courts, and we simply flag up there some practical questions which might arise about the extent of any such duty. If the appellants succeed in their position that there was a duty, what did she actually have to do to meet that duty? And this is discussed further in causation, which I'll just come on to. But in conclusion, on the evidence and findings and facts, non-steroidals were not a reasonable alternative treatment that Dr. Lavengel was required to discuss with Mr. McCulloch. The alleged duty just did not arise. Now, turning to my third proposition, the evidence led and facts found do not allow a finding of causal link between any such breach of duty and Mr. McCulloch's death. The relevant agreed issues are numbers 4, 5 and 6, and they are found in the Statement of Facts and Issues at page 81, but they're also found in this case at page 61, I think. Just check that. No, that can't be right. They're found in this case at one, two.
They begin at paragraph 601, I think.
Well, I think the issues are set out in paragraph 4, my lord, and that's at page 123 to 124, or as I said, they're in the Statement of Facts and Issues at page 81. So it's did the inner house and outer house err in law in not applying any principles discussed in Schomberg and Drake and Harbour? Whether the appellant's case falls in causation in any event, and should the matter be remitted to the Lord Ordinary. So, as set out in the respondent's case, in our submission there was no error of law in the courts below. Appellants must fail on the issue of causation given the evidence and findings of the courts below. The appellant's case on record about non-steroidals and causation is set out in the respondent's case at page 149. And as will be clear from that, the averments were limited, despite the respondent's calls upon the appellants in the record to specify the causal link between the alleged breach of duty and the death. And the respondent's pleadings are set out at page 150. So, in summary, the appellants did not aver or lead sufficient evidence to prove that had Dr. Lavengel discussed with Mr. McCulloch the option of non-steroidals, and that's in the absence of him having any pain, and in the context that she herself did not consider non-steroidals to be a reasonable treatment option, they have to prove that he would have wished treatment by non-steroidals, he would have been prescribed non-steroidals, and as a consequence, he would have survived. And so we say the appeal on causation must fail. And in particular, the evidence did not show that non-steroidals were likely to reduce an effusion as opposed to resolving pain. Both the Lord Ordinary and the Inner House considered the evidence in detail and were not satisfied that non-steroidals had that effect. Therefore, the appellants failed to prove that treatment by non-steroidals would in fact have prevented the death.
As I understand it, your case is that this isn't a case where there is a gap in medical evidence as to causation. The case being made against you apparently was that NSAIDs would have reduced inflammation. The reduced inflammation would have prevented would have reduced the effusion and prevented the pericardial tamponade, and therefore would have prevented the death.
Yes.
And this case simply wasn't proved.
That's right. There was expert evidence on the effectiveness of effusions, and as I said, both the Lord Ordinary and the Inner House considered that expert evidence. I was going to just have a
Lord Ordinary doesn't address the specific causation question, does he?
He doesn't address a specific causation question about non-steroidals. However, he accepts Dr. Bloomfield's position that it wasn't necessary to prescribe or talk about non-steroidals, and the reason Dr. Bloomfield said that was he didn't think they would give any benefit if there wasn't pain. Now, he accepted Dr. Bloomfield's position as being a reasonable one. I mean, obviously, the Inner House considered causation in a lot more detail, and I'll come on to that, but what the Lord Ordinary did say at 99 it's at page 256. And this was when he was dealing with causation, because initially before the Lord Ordinary he did find there was one breach of duty, and it was a failure to arrange for a further echocardiogram. And so at paragraph 99, he concluded that had a repeat echocardiogram been carried out on the 6th of April, although he did feel unable to make a finding that it would actually have been done on that date, he said it would probably have disclosed a material deterioration leading to a need for urgent treatment. Beyond that, any findings by me would be entirely speculative. There is simply no basis in the evidence for an assessment of whether, at whatever time it was commenced and whatever it may have consisted of, such treatment would have been likely to be successful in preventing Mr. McCulloch's death. So, as I said, firstly, the appellants had led evidence about the alleged efficacy of non-steroidals from Dr. Flappin. Despite this, the Lord Ordinary didn't refer to such treatment as being a possible treatment likely to prevent the death. So all we can say really about that is that it is consistent with the Inner House's view that non-steroidals would not have made a difference to the outcome, and it may be inconsistent with the Lord Ordinary having been persuaded that non-steroidals would reduce the effusion. But if I can just refer briefly to the law, my Lords, on causation, and this is dealt with in the Respondent's case, at page 150 to 151. So the legal framework there referred to is Gregg against Scott. My Lord, I think because of time, I won't take the court to that, but obviously the references there to the court's decision, which made it clear that conventional but-for tests for causation required to be satisfied. in the context of this, of Greg and Scott being a clinical negligence case. And in fact, more recently in the case of Juice, which has already been referred to, my Lord Hamblin at paragraph 69, and that's found at page 2839, Lord Hamlin also said that the claimant required to demonstrate but for the causative effect of the breach of duty. So what we go on to say then in paragraph 66, which is at page 151, is that the negligence alleged here is a failure to discuss with the deceased non-steroidals as a treatment option for reduction of the pericardial effusion. And on these facts, it would be necessary for the appellants to prove, firstly, that non-steroidals would have been discussed and what that discussion would have been. Secondly, that Mr McCulloch would have chosen to take the non-steroidals. Thirdly, the steps that would have been taken with a view to Mr McCulloch getting a prescription of non-steroidals. And this is in the context when Dr Labanjo reasonably does not consider them to be an appropriate treatment option. So she doesn't have to give him these drugs. She doesn't regard them as clinically appropriate. And then fourthly, when such non-steroidals would have been given, and finally, that non-steroidals so given would have prevented the death. Now, at 67, as we say, it's implicit in what the appellants invite the court to do, that they invite the court to make a number of factual findings, but they do not identify these apart from in their case at paragraph 83, and that's at page 112, when they invite the court to find as a matter of fact that the deceased would, if properly advised, have taken the option of a non-steroidal. But I say, well, they need to say more than that. They need to establish these other facts. And before this court interferes with the decisions of the findings of the court below, the court would need to be satisfied that there was an error.
Was there any invitation to the court below to make findings of fact on causation?
No findings of fact were sought.
There was no request for findings of fact?
No.
Well, it's hard to see how the court below can be said to be in error if they didn't make them.
Yes. I'm being reminded there was originally in the grounds of appeal that it did state that there had been a failure to make findings in fact, but that was departed from the Lord Ordinary.
I was specifically asking, was there a request to the inner house to make findings? No. And the answer you're giving me is no.
There's a point they emphasised in the reasons they gave for declining to grant permission to appeal.
Yes. And, well, in relation to the courts below, obviously the Lord Ordinary heard evidence and was satisfied that a responsible body of medical opinion held the view that non-steroidals had no benefit in this situation beyond pain relief, despite Dr Flappin's position to the contrary. And the Inner House examined the evidence carefully and have set that out in their opinion. So, in my submission, there has been no error by the courts below, in any event. So, Lord, time's running on, and there was reference to Drake and Chambry and McGee this morning. Now, we deal with that in our case from paragraph 68 onwards, and our submission is that we're wrong, the appellants are wrong in their suggestion that Drake or Chambry permit them to succeed in this case without establishing causation in the usual way in a balance of probabilities. In Drake, as is set out at paragraph 69, the facts found were that a fire was started by arcing, so that's an electrical discharge, in the cable used by electricians rewiring the plaintiff's house. There was negligence in the defendant's failure to check the cable before it was used, and the trial judge found that the fire was caused by the breach where there was no evidence of an alternative cause, and this was upheld by the Court of Appeal. Now, the references are there to specific observations of Lord Justice Longmore and Lord Justice Toulson, as he then was, but I think because of time I won't be able to go to those references just now, but I would take from these that where negligence is established, firstly, where negligence is established and where damage occurs of a kind likely to arise from that negligence, and where the court is not satisfied that alternative theories advanced as to causation are probable, or no such theories are advanced, then the court can infer that the damage was probably caused by the negligence. And as Lord Justice Toulson described it, there's a common sense evaluation of the evidence. It's not a principle of law or an alteration of the burden of proof. But clearly the facts in Drake were very different to the facts of the present case. And as it's in the Respondent's case at 72, there's reference to the appellant's reliance on Chambray, where Drake was referred to. But again, in my submission, Chambray doesn't help the appellants. In Chambray, it was agreed that had the deceased been referred to hospital by the GP, she would have been diagnosed as having pulmonary embolism, and she would have received heparin that day. Instead, she died at home the day after being seen by the GP, and that's found at page 3073. There was substantial evidence before the court as to what would have happened had the deceased been referred to hospital timelessly, and the way the trial judge put it at 3081 was that there had been very detailed evidence from experts as to what would have happened on the balance of probabilities absent the negligence. And in that case, the trial judge examined the evidence as a whole to assess whether or not it was likely that the deceased would have survived had she been admitted to hospital. So although the precise mechanism of survival was not proved on the balance of probabilities, the judge was satisfied that with treatment with heparin, the deceased's chance of survival would have been significantly increased, and on the balance of probabilities, her death would have been avoided. And the trial judge's decision was upheld by the Court of Appeal. And I would particularly refer you to paragraphs 55 and 56. So paragraph 55, which is at page 3088. So it said there, it seems to me that the respondent is right in the submission that the judge was attempting to find out whether a specific mechanism would in probability have prevented the death. He found that he could not do so, but death was the highly likely result of an undiagnosed and untreated pulmonary embolism. And then he referred to the expert evidence, which clearly indicated that she was most unlikely to have died in hospital. And then over the page, that was the judge's assessment of the overall evidence. The judge actually said the above evidence of Professor MP and Dr. Gomez in conjunction with the medical literature drives me to the conclusion that on the clear balance of the probabilities, she would have survived. And then at 56, the court said, in other words, without being able to prove the precise mechanism of survival to the requisite standard, after exhaustive consideration of all the material, the respondent did satisfy the judge clearly that the result that occurred was caused by the breach of duty. So we would say that Chambray is really another example of judicial reasoning to make findings of causation on a balance of probabilities, and in Chambray there was clearly substantial evidence relevant to causation in contrast to this case.
Now, we have reached 4 o'clock, Unless you're going to finish in just a minute or two, it might be better if we were to hear you complete your submissions tomorrow morning.
That's fine, my Lord. Content with that.
Very well then. Well, we'll adjourn for the day, and we'll sit again at 10:30 tomorrow.